All right, very good, counsel. This is case number 122199, Dennis Johnson versus J&S Scales Incorporated. Set over, and I think we continued this due to counsel's illness. Let's see, for the appellant, we have David Roberts, is that correct?
Yes, sir.
Even though it says Rick Roberts on your name tag on your Zoom.
Yes, sir. I'm one and the same. Long story.
All right. We don't need to hear that now.
Yes, sir.
All right. And then Mr. Bell, you represent the appellee, Dennis Johnson, is that correct?
That is correct.
And Mr. Roberts, did you want any time for rebuttal?
2 minutes, please.
2?
Yes, sir. 2 minutes, please.
You've got it. Now, counsel, because of the nature of the software, there's a little bit of a delay between when you make a comment and we hear it. And we have found it best that when the judges have a question, we'll raise our hand or something like that. So be on the lookout for that. Because oftentimes you'll be off, if we raise a question orally, you'll be off arguing something else and you have to go back. So we found that's a acceptable procedure. So be on the lookout as you're presenting your argument on that. So Mr. Roberts, we'll get you set up here on my timer. You may begin.
Thank you. May it please the court. Mr. Bell, good morning. I am David Roberts. I'm appearing on behalf of appellant defendants, which is Mr. Rebant and J.S. Scales. I am relying on the factual statement and legal arguments contained within their brief, and I incorporate that into this oral argument. This is a breach of contract case. After a bench trial, the trial court granted judgment based on its finding that the parties entered into an enforceable consignment agreement, which was contrary to the evidence presented at the trial and contrary to the parties' written contract, which is known as the asset agreement. And I'd refer to the glossary contained within my brief, which has all the parties and documents listed. This represented a misrepresentation of the asset agreement, which is the basis of this appeal. The asset agreement does not contain a consignment agreement. It does not contain a provision for a future consignment agreement. None of the documents signed by the parties contained a consignment agreement. The asset agreement does contain a statute of frauds provision, which required that any amendment to the asset agreement must be in writing and must be signed by all the parties. In order to reach an enforceable consignment agreement, the trial court found...
Counsel?
Yes, Your Honor.
As I read the record, it looks like to me it's undisputed that at the time of the actual closing that had been extended to allow your client to find financing, that there was $420,000, give or take $1 or two, in inventory. And your client was only able to bring $300,000 in financing to the table. So where does the agreement say that he gets $420,000 worth of inventory for $300,000?
Where does the asset agreement say that?
Right.
It doesn't, sir. That's the whole problem. That's the whole issue. There's nothing in the asset agreement that says what the sales price for the inventory would be at the time of the closing. The asset agreement, yes, sir.
Wasn't there an acknowledgement between the parties that the value of the inventory at the time of actual closing was $420,000 because the inventory fluctuated by what was sold and what came in, waiting on your client to obtain financing?
Yes, sir. Yes, Your Honor, excuse me. The agreement of the parties specified that at or before the closing, the parties would enter into a written document which would define the exact value of the inventory, and that never happened.
So doesn't the meeting of the minds occur with the email and also the corporate minutes that your client signed recognizing the $120,000, approximately $120,000 obligation?
Your Honor, and I understand the court's question. You're concerned about that. The issue is that the contract specifically provided there would be a written statute of fraud. So if there's going to be any amendments to the documents, they had to be in writing and signed by the parties. Now, both of those documents, those two documents, there was an offer that Mr. Rebant submitted, and which has been referenced to quite a bit, dated 11/26/10. That was his email consignment proposal. And as the brief reflects, Your Honor, this contract was negotiated over about a 2-year period of time between the parties. They didn't have attorneys. They did it basically between themselves. They did use counsel towards the end, but they didn't have attorneys to help them do this. In any event, the agreement, the asset agreement, provided that they would enter into this written agreement as to the value of the inventory at the time of closing. Now, that never happened. Mr. Rebant had SBA financing up to $300,000. And between the time of contract execution and time of closing, the parties continued to negotiate this issue. And so he sent this email, which he sent on his personal email. It was not on behalf of JS Scales, which is the buyer. Mr. Rebant is not, as an individual, was not a party to this action. It was between Mr. Johnson in his individual capacity and JS Fabricators in his corporate capacity, and JS as the sellers, and JS Scales as the buyer. In any event, Mr. Rebant sent this email and said, I am proposing to do this based on, because there was a monthly inventory value that was being exchanged between the parties. So at that time, it was, when he sent that, this email, they had exact inventory was between the $300,000 and the inventory was $116,492.19. So he proposed, he said, I would propose to take 16 specific items of your inventory and use those 16 items that have this specific value of $116,492.49, and we will consign those items. And so that would produce a $300,000, well, around $300,000 SBA payment or finance payment, and then this other payment. So he sent that to Mr. Johnson. Mr. Johnson testified he received it, and Mr. Johnson specifically decided upon receiving this that he would not agree to the any of those specific items of inventory, 16 items, for consignment purposes. He didn't want to do that. His testimony was, I didn't want to consign any specific items of property. What I wanted to do was take basically an assignment of sale proceeds. He wanted the initial sale proceeds to cover the difference. So that was his intent. Mr. Johnson then called Mr. Rebant, told Mr. Rebant, look, I am not going to agree to this, your specific items of inventory, and I'm not going to agree to any specific items of inventory. What I will agree to is we will do a quote unquote consignment of all of your initial sales of your inventory after the closing. And they didn't agree to a value. Mr. Johnson testified they subsequently talked again, communicated, and they came up with this $120,000 number. So Mr. Johnson then relayed that information to his advisor called Sunbelt, and they drafted this JS Scale stockholders agreement. And that agreement states that the inventory would be purchased for $300,000 cash money, and there would be a consignment of, quote, approximately $120,000, not the $116,492 that was in the consignment proposal, and not the $299,560 that was in the consignment proposal. There was no inventory description in there, and there was a statement that JS Scales would execute all the documents necessary to carry out the purposes of this consent. That was signed by Mr. Rebant and Ms. Rebant in their capacity as shareholders of JS Scales, but it was not signed by any of the parties. So Your Honor, I understand the court's concern here about this. The problem is Mr. Johnson believed, and he testified, he believed that when he had this telephone conversation with Mr. Rebant on 11/26/10, that telephone conversation, which Mr. Rebant denies occurring, but that telephone conversation constituted this written requirement of the stockholder consent form. So he never requested or obtained a written agreement because he believed, Mr. Johnson testified, Mr. Johnson believed that when they went to closing, this shareholder or stockholders consent agreement would suffice. The problem is, Your Honor, that never happened. Mr. Rebant, his testimony was he never received word from Mr. Johnson about this. And they just go to sales and he handed the money. And he handed him a cashier's check for $300,000. Mr. Rebant Mr. Johnson handed him the inventory. And by the way, Your Honor, to validate that Mr. Johnson did not want to consign those 16 items, he already had sold 3 of them by the time they went to closing. So about a fourth of the items were gone. Sir.
It seems to me you're arguing there was no agreement.
Well, there was no written agreement as required by the asset agreement. The parties never did that because it required the signatures, any agreement, because this would be an amendment. A consignment would amend the asset agreement. The asset agreement was totally executory. When they went to closing, the asset agreement would be payment and the parties would walk away. That would be the end of it. As a result, I mean, the asset agreement provided that Mr. Rebant would receive, J.S. Scales would receive the inventory and he'd walk away. There was no lien, there was no restriction. J.S. Scales could have done anything it wanted to do with that inventory at the time of closing. There was no agreement. There was no agreement. They went to closing. Mr. Johnson made an assumption.
That I'm not entirely sure that makes sense to me. There was no agreement about the assets.
Not enforceable, Your Honor, because they had a statute. There's a statute of frauds provision in the asset agreement. This constitutes an amendment. Judge Chambers the trial judge found that there was substantial compliance with he acknowledged that the parties entered into this agreement, the trial court did, that they did at arm's length. They negotiated this. They were bound by it. Judge Chambers acknowledged that. But the way to get to this decision, he said the parties substantially complied with the statute of frauds. Now, so the statute of frauds had to be complied with, and it wasn't. This case represents, Mr. Johnson believed, because he had this telephone conversation with Mr. Rebant, that this resolved the problem, but it didn't. It never got taken care of. So basically, they go to closing, they exchange documents, he gets his money, and they walk away.
You've got a little over a minute left.
Yes.
Well, and didn't Mr. Rebant pay Mr. Johnson $25,000 towards that inventory?
Well, he made a couple of payments, yes, Your Honor. And as he testified, the parties entered into a 1-year non-compete, a 1-year consulting agreement and a 5-year non-compete agreement. He wanted Mr. Johnson to continue to honor that. So he promoted that. But they did not have an agreement and they did not comply with the statute of frauds provision contained in the asset agreement.
So you're saying the minutes that your client prepared for his corporation was not sufficient to reflect a written agreement?
Okay, Your Honor, to be accurate, my client did not prepare those. That was prepared by Mr. Johnson's business advisor, because his business advisor contacted him and said, hey, you need to get a written agreement done here. That was his testimony. You've got to get this in writing. So they sent him that consignment proposal.
But Mr. Johnson signed it with his wife, is that correct?
No, Mr. Rebant signed it with his wife.
I mean, Mr. Rebant and his wife.
Yes, and neither one of those people are parties to this transaction. They were shareholders in JS Scales, but they are not parties to the transaction. For this amendment to be effective, it would have to have been signed by Mr. Johnson, which there was no signature signed by, nothing was signed by Mr. Johnson. It would have to be signed by by JS Scales and JS Fabricators, an authorized representative. That never happened. None of the required signatures are contained within this documentation.
Thank you, counsel. Your time has expired.
Thank you.
Are there any other questions from the judges? All right, very good. All right, counsel, we'll hear from the appellee.
Thank you. May it please the court and counsel. This contract was a contract that was executed between these gentlemen, and the mistake that Mr. Johnson made from the very beginning is that he became too friendly with Mr. Rebant, and he trusted Mr. Rebant too much. And Mr. Rebant took advantage of him. This defense about the contract not being able to be enforced with regard to the consignment of the inventory didn't come up until after the lawsuit was filed. Mr. Johnson's testimony at trial was that Mr. Rebant never said anything to him about the inventory not being consigned until after the lawsuit was filed. Mr. Rebant now wants to hang his hat on a provision of the contract that says the contract can't be amended unless it's in writing and signed by both parties. But the fact of the matter is, the contract was amended early on by both parties without it being in writing. The contract was supposed to close in June of 2010. And because Mr. Rebant couldn't obtain the SBA financing, the closing date was moved more than once. It was moved from June of 2010 clear back to February of 2011 by an oral agreement between the two guys. Nobody ever said anything about that needing to be in writing. It's only when Mr. Rebant wants to take advantage of the contract that he makes that argument. Yes, sir.
What does that mean? Does that mean that the statute of frauds provision is unenforceable because they didn't use it during the first time when they continued the payments?
I'm saying that Mr. Rebant can't use that as a shield when he uses it to, he can't use the statute of frauds argument to his advantage and when he wants to, but not have it used against him when he doesn't want to. It's the clean hands argument, I guess, is what it is.
So
But
you're not arguing that that provision of the contract is unenforceable due to their practice. You're saying it's some sort of equitable consideration
I
that
think
you can't use it, speak one way and use it a different way. Is that it?
yes, sir. I do believe it's unenforceable because I don't believe it's an amendment to the contract. And as I said in my brief, I don't believe that the way that the inventory was sold on consignment was an amendment to the contract. I believe it was a supplement to the contract because that provision in the contract never provided for how the inventory had to be sold.
So to clarify, what you're saying is that provision of the contract does not even apply to our facts here today.
That is my argument. Yes, sir.
Well,
two arguments.
Okay, thank you.
In that regard. With regard to whether or not there was a contract for the consignment of the inventory, Judge Chambers' ruling found, and I quote, the evidence was overwhelming that an agreement was reached between plaintiff and J&F Scales to consign the inventory in question to defendant, close quote. You have a situation where Mr. Rebant could only obtain financing for $300,000 worth of inventory. They couldn't put an exact value on the inventory because there was continued production between the time that the contract was executed and the time of closing. It was supposed to happen very quickly, but it didn't happen that way solely because Mr. Rebant couldn't obtain his financing. So when they get to November, that if you read that November email that was sent by Mr. Rebant to Mr. Johnson, Mr. Rebant says in that email, I'm not going to be able to come up with the other $116,000 worth of financing. I propose that we consign it. I don't agree with Mr. Roberts' argument that Mr. Rebant didn't have the corporate authority to send that email. He was one of two stockholders. Him and his wife were the only two stockholders of the company, and he was negotiating the sale and purchase of the assets throughout the entire time that he dealt with Mr. Johnson.
Counsel,
What Mr. Johnson,
Counsel, let me
Yes,
ask you, just before you leave that, to follow up on this, it's your position that the written agreement originally left an open term to be agreed upon by the parties later and not an amendment to the written contract. Is that your position?
yes, sir. Because they
Second-
didn't know.
Okay, so they left that open because they didn't know. And then second, is this transaction covered by the UCC?
I don't have the answer to that, to be honest with you.
Well, aren't we talking about sale of goods here?
Yes, sir.
And if so, how would course of performance come into play?
Say that again. I'm sorry.
How would the course of performance by the parties come into play?
I think the course of performance would show that Mr. Rebant acted from the very beginning through the very end of this as if there was a contract for the consignment of the inventory. He was the one that went to Mr. Johnson, and he was the one that proposed that the inventory be consigned. Mr.
Just so it's
Johnson,
clear, what is the inventory we're talking about?
scales.
And would they be goods?
Yes, sir.
Okay.
They're giant scales. They're scales
Right,
for
right.
trucks
But
to use.
they're big goods.
Yeah, huge goods. But Mr. Johnson didn't say, as Mr. Roberts, his argument was that Mr. Johnson objected to or declined that offer to consign the inventory. What he said was, I don't want to consign that specific inventory on the list. I think those things will be fine. I want to consign all of the inventory. And so between the time of the November email and the February closing, they continued to produce goods, continued to produce scales. And so on February 1, when they had the resolution of the stockholders, the stockholder resolution wasn't for the consignment of the specific items listed in the email. It was for the remaining inventory, approximately 120,000 being consigned. That's where that language in that stockholder consent comes in. And then they went to closing. And if you'll note, at closing, there was no bill of sale on the inventory because it wasn't sold at closing. It was, except for the 300,000. The additional inventory was consigned. Afterwards, after the closing, there were two payments made by Mr. Rebant on the inventory. Mr. Roberts wants to characterize that as payment for consulting. But one of the checks specifically on the memo line said it was payment for inventory.
And wouldn't that be a fact question, counsel, for the district court to decide and not for us?
What question? I'm sorry.
What the intent of that payment was, whether it
Yes,
was
sir.
for inventory or for other purposes.
It is a fact question. It does go to the intent. Absolutely.
And we would
and
yield to the district court on questions of fact.
Yes, sir. And that goes to the district court's finding that there was a contract as part of the performance between the two gentlemen in this situation. And so with regard to whether there was a consignment of this inventory, there's no question that there was. It was done to benefit Mr. Rebant. It was done at the suggestion of Mr. Rebant. It was done with Mr. Rebant suggesting not only that it happened, but he suggested the numbers. He was the one that got the consent of the stockholders and put everything in place for this to happen. He took possession of the inventory. He made payments for the inventory. He never complained. There was a later communication, if I may refer to my brief. There was a later communication in October of 2015. There was a letter from Mr. Rebant that says that he had received a letter from counsel regarding the inventory issue. It's my proposed findings of fact number 22, and it says, Mr. Rebant says, quote, "I received your letter along with a letter from your attorney regarding the consigned inventory. There appears to be a discrepancy in regard to the value of the inventory in question," close quote. He never says in there that there wasn't a consignment. He's only questioning the value of it. We've been chasing Mr. Rebant since 2011, but in earnest since 2015. Mr. Rebant's actions in forming these other entities and transferring these assets into those other entities, when we filed the lawsuit to obtain judgment and have Mr. Rebant pay to Mr. Johnson what was owed to Mr. Johnson, shows his character, shows his intent, shows his motive. Obviously, the district court heard all of the evidence and found that there was a contract for the consignment of the inventory without question. Mr. Rebant is trying to hide behind a provision of the contract that he didn't pay any attention to until after the lawsuit was filed. I'm asking the court to find that the trial court's judgment was fair and based upon findings of fact that are supported by the evidence, and affirm the trial court's decision.
Thank you, counsel. Judges, are there any other questions?
Well, I would like to ask Mr. Roberts, does the UCC come into play in this agreement, especially as to the inventory?
Our position, yes, Your Honor. I argued that in the brief.
All right, we'll go ahead and start your rebuttal time now.
All right, thank you, Your Honor. May it please the court, Mr. Bell. We need to focus on, well, first of all, these two individuals negotiated. They had offers and counter offers. This went back and forth. The whole purpose of the statute of frauds is to conceal things, not conceal, but to get everything to be concise and down to a document so everybody understands what they're supposed to do. Mr. Johnson knew that he was supposed to have a written agreement. He believed and assumed that this consignment proposal that his business advisor prepared satisfied that. And he assumed that his testimony was, my verbal conversation with Mr. Rebant on 11/26/10 satisfied that written obligation. So he never bothered to get that done. That was his testimony. If we would have had that done, we wouldn't be here today, probably. Now, the problem we have with this whole consignment thing is, number one, consignment title stays with the seller. We never did that. Nothing was ever consigned. For that consignment to take place, you have to say, this item of inventory remains mine. Buyer, you keep it, you sell it for me, then give me the proceeds. That never happened. On one hand, Mr. Bell argued that all the property was consigned. Well, then there would be no payment to be made at closing because everything would be consigned. His proposal, his stockholders' consent said there would be $120,000 worth of consignment. No assets, no inventory were ever identified for consignment purposes. It never happened. So we go to closing and the payment's made, they deliver the inventory, the transfer is made. At that time, Mr. Rebant could have done, JS Scales could have done anything it wanted to do with that inventory, anything. Now, this argument that there's some kind of waiver about continuing, and if Mr. Rebant wanted to continue the closing and Mr. Johnson said no, that was to his advantage and benefit because he wanted to close the transaction. So
Counsel, your time has expired, so if you want to sum up, I'd appreciate it.
okay. Yes, Ron, thank you. It's just, there was an unjust enrichment claim, which the plaintiff made, the court denied, it was not appealed from. That is where our position is, that is where the plaintiff's claim lies in unjust enrichment, if there is one, but that's not before this court. Thank you.
Thank you, counsel, for very interesting oral arguments today. We'll take the matter under advisement, obviously, and issue our opinion in due course.
All right, thank you.
And, thank you for your participation. We'll allow the lawyers